Attorney Gause, since you're the one I can see, can you hear us okay? Great.
Yeah, I can hear you fine, thanks.
Okay. Great. Here, David, can we get this
Sure.
started?
We all set.
I think so.
All right. So good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one, relevant factual errors, two, relevant omissions from the report of facts submitted during the investigation, or three, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask you introduce yourself as you come to the podium.
All right, so before we adopt the agenda, I just want to make sure that everybody is aware there was a case that was listed on the consent agenda H23-0404AB, Rose Earl versus Mary Beth Hassett and Robert Maloney. Due to a typo on the hearing notice, they were advised that the date to submit their submissions of disagreement was today, which obviously doesn't work if the commission meeting is today. So that case has been tabled and will be heard at the April meeting. Do I have a motion to adopt the agenda and consent agenda? And our remote participation policy requires me to make sure the commissioners' votes can be both seen and heard. So I will be polling the commissioners who will signify their vote both orally and visually. Now, do I have a motion to adopt the agenda and consent agenda?
To adopt the agenda and consent agenda.
Second.
Okay, it's been moved and seconded. Any discussion? Seeing none, if you vote yes, you're in agreement. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Welcome also Commissioner Sanders, our newest commissioner, joining us today for the first time. Thank you very much, Meg. It's your first vote.
Yes.
And actually, before we proceed, did you want to, I don't put you on the spot, you want to introduce yourself briefly to everybody?
Sure. So I'm Megan Sanders of Old Town, and I am delighted to be here. I practice law and do a variety of things for Penobscot Community Healthcare, located in Bangor, and really delighted, and it's an honor to be here. So thank you.
Delighted to have you. Yeah, that I feel like that happened really fast and really easily, which is exactly the way I think things to go. Yeah. So thank you for volunteering. We're very glad to have you. Okay. The minutes from the February meeting. I have a motion to adopt them.
So we'll.
Second.
All right, Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay. Director's report. So for administration, for personnel, two things. We had an investigator leave us and that position has been posted. I got the confirmation that it's been posted last week, so it'll be open for the next couple of weeks, and hopefully we'll be able to start hiring somebody for that position in the coming months. I will say that there is basically one person doing recruiting for the entire state right now. So everybody send her snacks and coffee and things. So things are a little backed up, and that's why she is working incredibly hard.
Who did we lose?
Max. Max. I'm not actually sure any of you met him. He was our newest investigator. He hadn't been to a meeting. He'd been to a meeting, but he hadn't presented that
Okay.
And Colin Hurd, who I'm not sure many of you have met in person, I believe you've seen him on the screen, is moving into the deputy counsel position, which we're very grateful for also and very excited about. And also, we're very excited to get that new investigator hired. Colin will be wrapping up his investigations, but not to his delight taking on any new ones unless we get really backed up.
Welcome, Colin.
You always seemed like you kind of enjoyed those investigations.
Some of it I did, yeah. Some of it, it's like anything there. It's good and bad, pros and cons.
Not nearly as much as he's gonna enjoy doing discovery.
And I know I told you all that we had hired Michael Whitman as Director of Operations last, and he was at his orientation at our last meeting. So here he is in person. Michael's our new Director of Operations, and he, I'm not exaggerating when I say he's a godsend. When we were in the middle of the biannual HUD audit when he started, and I have been doing all of the budgeting and accounting for the last 7 months, and we're still around, which is miraculous. And I basically just handed Michael all of HUD's budget questions and said, can you figure this out? And it was so pretty. He gave me the nicest Excel sheet. HUD's very impressed by it. So thank God for Michael. We're all very excited. And he's since created more beautiful and understandable Excel sheets, which is the key. And is keeping track of all of our invoices and accounts and all of that stuff.
Look at it. I was gonna ask, who did can't open it now, so it's happening.
Oh,
iPad again, but
that enormous Excel sheet that I sent you?
Yes.
That was not Michael. That was the budget office. Michael's would have been much more understandable. Although they send us the same thing, and I'm starting to understand what it says. But I was supposed to give that to you last meeting at our quarterly meeting, and we didn't.
I had some questions, but I can't.
Thank you. Hey, I'm happy anyway, because company that I have here for, so.
What else? Compliance. We have. No, upset.
So which of these reports are you?
I'm doing that one. now.
Okay.
I will be momentarily.
It helps to point us to.
Yes, so the conciliation status memo. We have 6 cases in active conciliation, down from our 10 last meeting. 5 unsuccessful conciliations and no successful conciliations, so no agreements for you to approve today. And for the case summary report, we have 50 new charges in February. A total of 18 dismissals, 9 administrative dismissals, 6 right to sue requests, 2 withdrawals without benefits, and 1 case that settled in mediation with about 20,000 to complainant.
Is that failure rate for conciliation abnormal or just comes and goes?
Comes and goes.
Yeah.
Yeah, comes and goes. I think especially when we've had a lot of cases in conciliation the last few months, and I think we have sort of anywhere between a 10 and 20% success rate at conciliation, so it's not that many to fail.
It's that low.
Sometimes more, but I think it's usually about that. I think it's about 30% for mediations that are successful. For litigation, I would ask that we take that in executive session. And for new business, the legislative session proceeds apace. It is still on target, I think, to end mid-April. So all of the bills will presumably go into effect mid-July. If we get done in time today, I'm going to a work session on a bill that the supplemental budget includes an approved reclassification for Jane O'Reilly, who, as you know, has been our lead investigator for about 1.5 years without ever having been paid for that job. So that finally got approved and now it's in the budget, and with any luck, that will go into effect and she will start being paid for her job in July. We thank her for her patience. Everything else, I think, is headed to either the floor or appropriations. Updated, we don't have much in this right now, which is nice. It's been quiet for the last week or so. Questions, concerns, anything?
So we've got 3 minutes, 4 minutes. Till 8:45.
One quick question, on the budget, but what is Lighthouse Consulting in? And another question I probably should, couple. There was some revenue from a seminar, what is that?
I am also still familiarizing
Yeah.
myself with these reports.
Well, I'll just throw it out there and then you can tell me.
You're looking at the budget, Julie?
Well, I was looking at the budget, now I can't open it. but- Yes, the budget.
Yeah. Give me, my computer a minute, it's slow today.
We should probably discuss the IT situation during executive session. Yeah, the situation.
Oh, with your iPads.
Everything.
Yeah,
You too.
Oh, yeah.
Yeah, so they
40
changed
minutes
them.
last night, right?
Okay, good, I don't feel so.
No, I got hold of Tech Live Friday. But they updated something and wiped out our forever update. Yes, right, and he said that might happen next month.
He sent an email and say, we updated something, this is what you mean.
Yeah, I don't check that
Julie,
email.
what are you looking at?
I'm looking at,
Is it the,
it's under the, now, see, I can't get it, but it's under revenue. And it's a seminar, says we have revenue. We have revenue from it. And I just wonder, do people pay us for seminars? I know.
I don't see, so I'm looking at the revenue tab and I don't see
Second page.
second page.
Yes, I can.
Oh, that, so there is money in that fund. It's not, it's not money that people have paid us. It's
Okay.
usually, I think it's money that we put in there from the federal grants that we get, so we can put on
Okay.
seminars if we
Okay,
we're going to do that.
okay. And
But that money has been in there for a long time.
one more quick question, I think, and I probably should know this, but the federal funds that we get,
Yes.
are those, it looks like it's an allotted amount that we get that you can budget. It's not a case by case basis.
It is a case by case, so it is a case by case basis. The EEOC and HUD pay us a set amount per case.
Okay,
EEOC generally just like, yep, here's your, I think it's $830 per case for every case, and they don't do a ton of oversight on that.
okay,
HUD pays us a lot more per case,
Yeah.
but also asks for a lot more information about them, but we voucher for those cases about twice a year. So we get a set amount, we say we've done this many cases, EEOC confirms and sends us a check.
okay. Can't find it. Thank you. Thank you.
Okay.
It didn't look like it was case by case because there was a chunk.
Yeah,
but.
Yeah, it is a little confusing.
Okay, thanks.
So I guess we are ready to go, huh? So the first case for hearing is William James, the petitioner versus Portland Air Freight. This is a recommendation by the investigator for a finding of no reasonable grounds. And therefore we will hear from the complainant.
Good morning, Commissioners. My name is John Gause and I represent the complainant, William James.
You guys, did you want to reserve any of your 10 minutes?
Yes, I'll reserve a minute of it.
Okay.
Please.
Just ask everybody, sorry, just to please not use any third-party names of people who are not in the not named in the report. All right.
So William James is a truck driver. He applied with Portland Air Freight, who's the respondent here on September 11, 2021 to be a tractor trailer driver. He had 2 years experience as a tractor trailer driver, along with other prior experience driving flatbed truck, tow truck. He had an active CDL through July 29 of 2024. On September 20th, the safety director, who was based down in Scarborough, was already doing an onboarding for somebody else up in Bangor where William was applying. So he brought William in and did an online, an all-day onboarding training session with William and the other driver. William was paid for his time for that. Nearly everything was complete except for one of these DOT medical certifications. William gave his existing 2-year medical certification that was valid until February 10 of 2023. The respondent did not find that acceptable, so they sent William to their medical examiner. Their medical examiner saw William on the next, or 2 days later, on September 22nd, 2021. And did a complete examination, cleared William to drive, said that he was safe to drive, did put a caveat on that, which was that within 6 months, William was to see a neurologist to verify his safety to drive. Portland Air Freight respondent here told William that that was not good enough, that he needed a 1-year certification to start working for Portland Air Freight. Next day, William provided, in addition to the 2-year certification that he had, a note from his primary care provider clearing him to drive, saying that his CP did not interfere with his driving in any way. At that point, the respondent had received the referral from its medical provider to a neurologist, and William was in charge of setting up and paying for that visit with the neurologist himself. But they did send a copy to Portland Air Freight that identified the reason for the referral being William's history of cerebral palsy. He has one leg that's slightly shorter than another. That's effectively the only thing that is a symptom of his cerebral palsy. He did then arrange and pay for his own visit with a neurologist. He saw a neurologist on October 26, 2021 in Lewiston. That person, as expected, did verify that William was safe to drive. And on November 4, 2021, that neurologist faxed his notes to Portland Air Freight's medical provider. Medical provider received and reviewed those on November 5th. William called on November 5th and said, does that mean that you can give me the 2-year certification? The medical provider said, you have to get a referral back from Portland Air Freight. So William sent an email to the safety director asking if that would happen. Did not hear back until, that was on a Friday, until the following Tuesday, when the safety director sent him an email saying that he wanted to talk with him. William called him, and the safety director said that they no longer had a job for William. Did not say anything about losing a customer. Then on November 18th, Portland Air Freight posted driving positions saying that they were urgently hiring drivers. William saw that through Indeed on November 21st and emailed the safety director saying, I thought you didn't have any positions. Safety director never got back to William. So that's what brings us here. There are three reasons that this is a violation of the Maine Human Rights Act. First, the Maine Human Rights Act requires that if an employer uses a test or eligibility criteria that screens out a person or people with disabilities, it must be job-related and consistent with business necessity. Here, that's exactly what happened. As of September 21st, William had been through the onboarding process, had seen the Portland Air Freight medical provider, had been cleared, DOT medical cleared by the Portland Air Freight medical provider to drive safely, and he wasn't hired. So as of September 22, 2021, he was screened out as a result of this one-year certification requirement that respondent has pointed to. So that has to meet the Maine Human Rights Act test of job-related and consistent necessity in order for this not to be a violation of the Maine Human Rights Act. The only thing that they say in terms of justifying it is that it's an industry standard and that it gives them an assurance that a person's going to be around after they've invested in training the person. Neither of those meet the business necessity job-related requirement. Industry standard is certainly not enough by itself if it violates the Maine Human Rights Act. We don't know if it actually is, but that's the only testimony that we have is that it was an industry standard. In terms of the cost of hiring and onboarding, here again, William had already been through the orientation on September 20th. He had been through the entire day of training. And regardless, it's not a situation where if Portland Air Freight hires somebody that is otherwise eligible, they're going to have to lose that person after 3 months or 6 months, whatever the case may be. It only means that the person needs to be reevaluated. And of course, usually someone who gets less than a one-year certification, whether it be a 3-month or a 6-month, is going to be someone with a disability. So that's going to be screening out a lot of people with disabilities in the name of just needing to reevaluate them. William, of course, was safe to drive, as was verified later on and was previously verified when he got the 2-year medical certification. So it violated the Maine Human Rights Act to have the requirement in the first place, but then also they did not reasonably accommodate him because he had already provided them with all of this information, clearing him to be safe to drive. They had already onboarded him, already provided him with a full day of training. So there's not a defense here that there's a lot more that they needed to do. He had 2 years experience driving already. And to hold him up because of their 1-year certification requirement, while he arranges on his own to be seen by a neurologist, placed an unreasonable burden on him, plus it failed to hire him. And from their perspective, to simply bring him on board, there would not have been an undue burden. So there's a failure to accommodate him by modifying their 1-year certification requirement as well. And then overall, in addition to not hiring him on September 22, 2021, because of his CP, and again, they were fully aware of his CP, both from his medical provider's note describing it that was sent to Portland Air Freight and from their own provider's note saying that the 6-month certification was given because of his CP. So they failed to hire him because of CP on September 22, 2001. And then on September 18, 2021, when they were urgently hiring drivers, at that point, Portland Air Freight knew that William had been cleared by his neurologist, and they knew that all that needed to be done was for him to be sent back if they wanted him to get the 1-year certification to their provider, their medical provider, and they did not reach out to him, despite the fact that they were urgently hiring drivers on November 18th. Rather, William saw the ad. He contacted Portland Air Freight 3 days later and did not hear back from Portland Air Freight. So there was a second failure to hire as of September 18, 2021.
Thank you, Attorney Guz. That was very, literally my timer was just about to go off as you wrapped up, so well done. Questions for Attorney Guz? Commissioner David.
Attorney Goss, does he ever see the medical provider hired by the company?
He did see that provider on September 22nd, 2021. That medical provider did a full medical workup and cleared him to drive.
Does he give him a certificate, if that's what it's called?
Yes, she did give him a certificate, and that's the only thing that the DOT requires for medical safety to drive.
Was there a length of time to that certificate? Is that the 2-year certificate?
That certificate, I mean, the medical provider has a number of options after evaluating somebody. They can either refuse to give a certificate saying the person is unsafe. They can defer until they get another medical specialist to weigh in on it, or they can clear the person to drive safely. This person cleared William to drive safely and then said that within a 6-month period, he had to be evaluated by a neurologist, a neurology specialist, as she said, in order at the end of that 6-month period for their medical provider to continue the certification.
And he's evaluated by the neurologist, but doesn't he have to go back to the provider?
He has a 6-month time frame within which to be evaluated and to go back to the provider. Here, it was October 26th that he was able to be seen by a neurologist. The neurologist verified that there's nothing about, his one leg being slightly shorter than the other that prevented him from safely driving, faxed the information to Portland Air Freight's medical provider. They received it on November 5th. William said to the medical provider, does this mean you're going to, give me a longer certification period? Medical provider says Portland Air Freight has to send you back here for us to do that.
Portland Air Freight has to what?
Send you back here for us to do that.
And that was never done.
Portland Air Freight never sent William back.
As I understand it, you're asking us to find that this requirement for a 2-year certificate is discriminatory because it screens out disabled individuals, correct?
No. They have a requirement for a 1-year certificate, and our position is that needs to be consistent with a business necessity and job-related if it screens out people with disabilities. Here, it did screen William out because September 22nd, 2021, he would have been sitting behind the wheel of a Portland Air Freight truck and driving it if it had not been for his CP. So they have to justify that 1-year requirement. All the DOT says is that you have to be cleared to drive by a medical provider who is on our registry. He was cleared by a medical provider on their registry to drive. 2, actually. Portland Air Freight's in his own. So he had already met the DOT requirement to drive. Portland Air Freight has an additional requirement, which is its own, that certification needs to be 1 year. In order for that not to be discriminatory, it has to justify it with job relatedness and business necessity.
Commissioner O'Brien and Commissioner Cox.
Oh, I'm sorry, were you done?
Yeah, no, go ahead.
Attorney Goss, I think I read in here that Portland Freight had never hired anyone who did not have the 1-year certificate. I mean, you said it was Portland Freight's policy. So it does, I think, following Commissioner David's question, it does appear that you're saying that the policy itself is discriminatory. If I remember correctly, and I apologize for my iPad, but that, again, no one had ever been hired, so everyone had to go through the same, my word. You know, everyone had to do the same thing. So I guess,
I'm sorry.
no,
As far as we know, that is the case, meaning that, meaning we haven't done discovery on this case yet, but as far as we know, we have to take, for today's purposes, Portland Air Freight's word that they applied this 1-year certification requirement to everyone. So it's not our claim at this point, based on what we know, that they're, selectively applying it to only William. Our point is that the policy itself is discriminatory if it screens out people with disabilities. We don't know how many other people were screened out as a result of it because they're not here, but we do know that William was screened out because of it.
okay, thank you.
Thank you. Attorney Dawes, good morning. You can see me, sort of. Yeah. Yes, so I'm looking at the investigator's report, and I'm looking at page 3 specifically, and it says complainant failed to establish his prima facie case because he did not establish that he met the minimum requirements for the job sought. And just to sort of clarify your remarks, you disagree with that, right? Because he had these other certifications. And another point that I'd like to discuss a little more with you is this business about this call that may or may not have happened around the 21st, right? Your guy sees that they're posting or, to urgently hire other drivers. He checks in and says, hey, what's going on? And then the company says, respondent says, they told him he could get a job as soon as he completed his requirements. And your client says that the call never happened. So just going back to my first question, you feel that your client did or would have met the minimum requirements that he had been permitted to. Is that accurate?
He met the objective requirements to drive when he showed up, for sure, based on all of his prior experience driving, a CDL that was valid until July 29, 2024, his medical certification that was valid for more than a year until February 10, 2023. So objectively, he met all of the requirements to drive as of that point. With respect to Portland Air Freight's requirement in particular, they required, in addition to all that, that he see their medical provider, according to them, and that he receive a certification that was going to last for 1 year. So as of the point that he saw their medical provider, that medical provider said, you're safe to drive for at least the first 6 months. And then you have to be seen by a neurologist that's going to verify what we say. So at that point in time, he actually did not meet their subjective requirement because their medical provider had not given him a certification that was going to last for a full year. He did meet that as of November 26 of 2021, when he saw that neurologist who did exactly what their provider wanted. So he had met the their medical provider's requirement that her opinion be verified. She had not yet translated her 6-month certification into a 1 year certification because Portland Air Freight hadn't sent William back yet. I don't know if that answers the question or not.
Right, but isn't it your position that if they had sent him back, he would have obtained that 1 year certification?
Absolutely. Absolutely. And that's exactly what happened when William, the next year, a few months later, applied to work for a different provider. excuse me, a different company. And, based on that neurologist notes alone, their medical provider said, sure, this is all we needed.
Right, and then with respect to the non-discriminatory reason, there are two things in the report. The lack of the one-year certification, which I understand where you're coming from on that. And then the fact that they had no business. Now, isn't that undermined by the fact that they're urgently hiring at the same time they're telling your client that they're not hiring, they don't have a need for drivers?
It certainly is from our perspective. I mean, that's 9 days later that they're urgently hiring. I understand their position to be that they had lost a customer, which when William spoke with the safety director on November 9th, they were saying that they were not hiring, but within 9 days, they were urgently hiring. So whatever, we haven't done discovery. We don't know the exact timing of, when or whether they lost a customer or when the customer came back, if they did. But our point is it's all in the same time frame, and William is certainly still on the table as an applicant.
Right. So in terms of this lost customer, what you're telling us is basically what you know, right, at this point?
Correct.
Okay. All right. Thank you.
Commissioner Sanders.
Good morning, Attorney Gause. I have a series of questions, and perhaps the answer is that you haven't been able to establish the facts because discovery in the context of litigation obviously hasn't happened yet. But I'm curious about, so respondent, right, has communicated that this one-year certification is consistent with industry standard. Your argument, of course, is that while that may be the case, right, assuming, let's assume for a minute that that's the case, it violates the law because it doesn't accommodate individuals with disabilities appropriately in a way that's consistent with the law. I'm curious, as you've worked through this commission process, if it is true that that one-year standard is consistent with sort of prevailing practices within the industry, have you found any litigation, either in this jurisdiction or in other jurisdictions, where courts have, opined on that question? It would seem to me that if it's true, right, if it is a one-year sort of prevailing industry standard, you're arguing that that's inconsistent with the law to the extent an employer doesn't accommodate a person with a disability, there'd be litigation elsewhere opining on this question. Have you found any of that?
I haven't found any cases indicating that the 1 year is an industry standard. And by industry standard, I mean, my understanding of what Portland Air Freight is saying is that means that other companies are doing that. And, that's a, prevailing practice among other companies. We don't know, I mean, even if that were the case, we don't know whether these other companies that may be doing it, if they are, make exceptions for people with disabilities, which would be what we're arguing for here, is that they should make an exception to it, even if it is their practice, if it's screening somebody out. But to answer your question, I haven't found any cases that either indicate that it is an industry standard, and certainly none that say that it's consistent with that it's job related and consistent with business necessity. And frankly, I don't know how someone could successfully argue that, because DOT is what they're meeting here, and DOT doesn't have any durational limit on safety. It just says you have to be certified safe to drive. It doesn't say that has to be for 3 months, 6 months, 2 years, whatever. So for a company to come in and say, we want more than the DOT requires, we want 1 year, they need to have a strong medical basis to say that. Here, Portland Air Freight says, we don't know anything about the medical side of things. So I don't know how they could justify it here or somewhere else where it's going above and beyond what DOT, who are the experts in this area, say is required.
Thank you. Also to Attorney Gause, is the DOT regulatory framework the only applicable regulatory framework that we're working with here, or are there others?
This is the only one that I'm aware of, I mean, in terms of this safety issue.
And understanding too that, you know, you haven't been able to participate in the discovery process. Do you know, did it come to light in the context of the document production that the complainant and the respondents engaged in this particular case through the commission process? Do we know at this point, how many more drivers did the respondent actually hire in the immediate aftermath of, you know, having that customer come back to the, you know, respondent's business?
I don't know that, and I actually question whether anybody was even involuntarily let go as a part of the respondent has not said that anybody was fired as a result of the customer leaving. It said that they were not hiring actively, and I imagine that they had some people who voluntarily left, possibly. I don't know that because we haven't done discovery. But for sure they were actively hiring within, you know, a matter of days.
And then finally, in follow up to Commissioner Douglas's question with respect to this November 21st phone call, why is it, if you know, through the commission process, why don't we have evidence at this point to establish whether in fact that call happened or in fact that call didn't happen? It would seem to me that that would be a reasonably easy fact to establish.
So initially, there was an affidavit that was submitted by the safety director saying that he left a phone message for William. And after William sent this November 21 email saying, "I thought you weren't hiring," initially, he said that he left a phone message. We responded that William never got a phone message. And our, you know, position on it is that if you look at the November 5th email from William that says, you know, he said, "I've been cleared. Are you going to send me back to the medical provider?" The safety director responds to the email and says, "I'd like to talk with you." There's nothing like that here. There's no phone message. So our position is certainly that he never called.
And the respondent hasn't produced at this point, for example, phone records to establish that that phone call in fact was made?
No, they have not.
Thank you.
Any Commissioner?
I'm confused about the phone calls and the emails. I thought that this ended with a respondent sending an email that he would like to chat. Is that not correct?
So on November 5th, when William said, "I've been cleared, are you going to send me back for my 2-year?" The safety director emailed back that next Tuesday saying, "I'd like to talk with you." And that's when the safety director said, "We no longer have a job for you."
Oh, okay.
The later emails when William saw the job postings on Indeed and said, "I thought you didn't have any jobs," and that's when he didn't get a response.
You got no response after that?
No response.
Is your position that it's a ruse that he says, that the company says, "We lost the customer, we're not going to hire right now"?
I don't have a basis to believe that because we haven't done discovery. So I'm taking them at their word that they lost the customer on November 5th. But our position is that he should have been hired on September 22nd anyway. And then even if they did lose the customer, they certainly should have hired him on November 18th when they were urgently hiring.
And what do you say to the requirement that he would have to make a request for an accommodation if it's a request to accommodate a disability?
That's backing up to September 22nd when he had seen their medical provider. He had provided his own and been cleared to drive, been cleared safe to drive, provided his own PCP's note describing in detail his condition and why it didn't interfere with his ability to drive. He had provided them with a 2-year certification from a DOT certified medical examiner. At that point, that's all the information that they need to provide a reasonable accommodation. It's like someone showing up at your step without a ramp who uses a wheelchair. They don't have to ask to get in with a ramp. You know, the business needs to know to accommodate under those circumstances.
And the accommodation would be waiving the requirement for a 1-year certificate from their medical contractor.
Sure. I mean, at least until he's seen by a neurologist, bring him on board, you know, bring him on board, put him behind the wheel. He's already been trained. You know, he's been driving trucks for 2 years, tractor trailers, other trucks longer than that. Put him behind a wheel. And if there's a problem with the neurologist down the road, deal with it then.
Thank you.
Commissioner Sanders.
I'm curious, Attorney Gause, in the commission process with the exchange of documents that would have happened prior to today, have you seen the respondents' employee handbook and or any of their policies relating to disability accommodation?
I may have, I don't recall. I mean, a lot of employers have a general statement that they do not discriminate. And I don't recall whether I've seen something like that with them.
But have you seen anything specific by way of writing that relates to, you know, the employer, in this case, respondent, understanding their obligations to, you know, for lack of a better expression, make exceptions to policy, right? Where those policies as applied have disparate impact on individuals with disabilities. Do you see anything like that?
I don't think I've seen their, you know, their full policies. No, I haven't seen that. And I don't think I've seen their full policies.
Okay, thank you.
Any other commissioner questions for Attorney Gause? Okay, seeing none, Attorney Gause, you'll have 1 minute when we come back to you. Attorney Frame, would you like to reserve any of your time?
Sure, I'll reserve a couple minutes.
Whenever you're ready, go ahead.
Frame.
Frame.
Yeah. Good morning, everybody. My name is Greg Frame, and I represent Portland Air Freight. I ask you to affirm the investigators' recommended decision here. I think it's important to understand what Portland Air Freight does. You've probably all seen them. They're moving freight throughout the state of Maine and New England on trucks that are 80,000 pounds. It's a heavily regulated industry, and this is an incredibly safety conscious company. The investigator had a chance to discuss safety at length with Alan Reed, who's the president of Portland Air Freight, as well as Pete Marion, who's the safety director. Alan Reed has been in the industry for decades. He's on a number of safety boards relative to motor carriers. And Portland Air Freight has you know, the DOT has requirements that employees who are driving truck need to pass a physical and need to pass a drug test. And the provider for each of those needs to be certified by the DOT. Employers can choose their provider, and that, you know, it may or may not seem intuitive, but to me it is. You know, Portland Air Freight wants to have consistency in terms of the medical feedback or the feedback they get from their provider. They are not willing to accept the certification of a provider that isn't of their choice. When the provider certifies someone for 1 year, Portland Air Freight knows that there's consistency because that provider knows their business and knows what is expected. Portland Air Freight's safety record really speaks for itself. And I don't want to belabor that point. John did a really good job of explaining kind of the timeline in terms of the beginning of Mr. James's interactions with Portland Air Freight. He was never an employee. The job description makes very clear that a one-year certification from a PAF provider is required. So he did take that training session. He did start the process of becoming an employee. Tellingly, the one piece of kind of documentation that Attorney Gaz during the investigation pointed to as indicative of employment was a document that laid out, the check the box of the things that need to be done to become an employee of Portland Air Freight. And missing from those check the box were the two very important things here. At the beginning, Mr. James attempted to give Portland Air Freight his own doctor's document certification, and PAF rejected that. That's not disputed. It's not disputed as well that the job description and the position is very clear of the one-year certification. When Attorney Gaz was talking about job-related and consistent with business necessity, there seemed to be this kind of, I would say, almost like a hard to explain, but as if Portland Air Freight was making up kind of these rules whole cloth to screen out people. This is absolutely job related to Portland Air Freight. Safety is the number one part of the job, and Portland Air Freight wants to ensure, and indeed has ensured over the years, that it has that the people it employ have been screened by their provider and have reached the thresholds that they consider important. Alan Reed, again, has been on a number of boards, and there's some testimony that, well, you can go to certain places and work right away with a 3-month certification. There's also testimony that you can go some places where you need a 2-year certification. Portland Air Freight over the years has determined that 1 year is important for it because it provides for driver retention. It applies for consistency across the board. I want to speak a little bit to the timeline and around the loss of a customer. This isn't like someone lost a very, very small customer. Alan Reed testified, and the investigator can speak to this, that Portland Air Freight lost 20% of its business. That's not an insignificant amount. And so when that customer was lost, there were no jobs available. That customer realized later that, in fact, they wanted to continue to work through Portland Air Freight, and so jobs became available at that point. But this wasn't I think the question was the loss of a customer a ruse or a sham or a pretext? That was a very significant piece here. So it's undisputed that Mr. James never completed the paperwork necessary, or not the paperwork, but the important steps necessary to be hired. It's also important, I think, to understand that when we're talking about job related and consistent with business necessity, I feel like there's, again, this component here that it's not that big of a deal, and that PAF's Portland Air Freight's, the parameters it has around hiring are kind of made up, or there should be more latitude in that. The argument being made is that the complainant should be able to use a different provider and a different standard, and that PAF's kind of decades-long policy of having a consistent provider, uniform provider, and a 1-year standard, which has been vetted time and again and has been shown to work given their safety record, is not job related or consistent with business necessity. And I think that's just falls in the face of the reality here. So in short, I'd ask you to affirm the investigators' recommended findings and uphold the investigators' recommendation. Thank you.
Again, just as my timer was about to go off. Both of
Wow.
you. All right, questions for Attorney Frame, Commissioner Douglas and Commissioner Sanders.
Yes, Attorney Frame, good morning.
Good morning.
Yeah, so you led off your presentation with a number of comments about safety. And I guess I'm wondering, you know, how the safety of complainant and the safety of other people is implicated here. I mean, the way I read this record, the complainant he had been cleared by his neurologist, he'd been cleared by the provider for 6 months. I think Attorney Gaz's submission indicates that, and correct me if I'm mistaken, the only reason why he received a 6-month certification was because of his history of cerebral palsy. So I'm just a little confused as to what you're getting at with the safety issue. I don't really see a safety issue here. I just see a sort of durational issue.
So the safety piece, can you frame the question, ask me the question again, because I want to make sure I get it right.
Yeah, I guess what I'm specifically wondering is what were your safety concerns, given that this man had been cleared by his neurologist and cleared by your provider for 6 months? The only qualification in terms of that 6-month certification was that he had a history of cerebral palsy. So I guess it seems like he was safe to drive for the 6 months anyway, according to your own provider. So what are your safety concerns?
Well, there's the, yeah. So first of all, Commissioner, there's the safety piece and there's the retention piece and the financial piece. So I think they're all tied together. The Portland Air Freight wants to ensure that their drivers have a 1-year certification. At the outset, Mr. James brought a certification from his own doctor, and Portland Air Freight said that that's not acceptable. You know, and I don't want to speak disparaging of the healthcare system at all, but if you have different providers, you're going to have different outcomes. You may have some providers who focus on one particular issue, some providers focus on another. That provider has no knowledge of Portland Air Freight and what's important to Portland Air Freight in terms of safety and what Portland Air Freight does. So the initial documentation didn't meet the requirement, and indeed, he didn't ever receive a 1-year certification from a Portland Air Freight provider. The difference between 6 months and a year, I think, is your question. I think that gets to was he safe? That's a Portland Air Freight isn't making the determination on safety itself. It's relying on its provider and the parameters it sees are important, that are consistent, are job related, consistent with business necessity, in terms of we want people who are certified for a year. We're not continually going through the recertification process, where it provides for greater employee retention, and we have consistency in terms of the drivers that we're going to get.
Okay, all right. So skipping ahead to this call that may or may not have occurred, right after the complainant is told there's no longer a job available. He sees that your client is urgently hiring, and he reaches out and says, "What's the deal?" And the complainant says there was he didn't get a response, and you folks claim that you reached out to him and said, if you complete the requirements, you could be hired. But I'm just wondering, what's the evidence that there was actually a call made?
Well, I think the evidence that the investigator had an opportunity to interview Peter Marion, who's a safety director, who's been there for a number of years. And certainly, he testified that he called. So that's the evidence that has been presented.
Okay, so let's just assume for a moment that I'm wondering if the call was made. Let's assume a call was not made. Why did your client not actively seek to rehire the complainant once this loss of business returned, right? Once this client is back in the fold? I take all that as true.
At that point, the complainant still had not had a 1-year certification from a PAF provider. Not had that at that point. So they're still not eligible according to the job description, according to the posting, to be hired by PAF.
Okay. And Attorney Gauze told me in response to my questions earlier that if he had been reevaluated, no question he would have received that 1-year certification. Do you have any comment on that? You agree or disagree? Or
I don't have any basis to agree or disagree, Commissioner. That's a decision that we've made by PAF's medical provider. We're playing fast and loose by playing a little bit of doctor here by saying, well, he's for sure at that point. I mean, is it possible? Is it even likely? Perhaps, but that's why Portland Air Freight engages with the provider, is to have them make the decisions based upon the qualifications that Portland Air Freight puts in place.
all right, thank you.
Commissioner Sanders. Thank you and good morning. I want to follow up to Commissioner Douglas's last question. I think what I hear you say is that the respondent didn't hire the complainant right as of that sort of November 21 phone call, which is in dispute at this point, because he still hadn't received that 1-year certification, which was consistent with respondent's policy. Can I ask though, Attorney Frame, isn't it respondent's obligation at that point though to continue to participate in that interactive process that they have with a post-hire, presumably, right? This individual is a post-hire pre-employment in that status. What was the respondent doing by way of the interactive process for disability accommodation?
So I think first of all, welcome, Commissioner Sanders. I think if you look at the investigator's recommended findings, I think the investigator discussed that very issue. It said that the complainant's disability did not prevent him from kind of going to the provider and reaching the certification needed for Portland Air Freight. So this really wasn't a question of, I think the investigator said, first of all, Mr. James never asked for the accommodation. I get Mr. Attorney Gauze's point there. But the investigator also said that, the disability did not prevent Mr. James from going to the provider nor from getting a longer certification. And therefore, that kind of interactive process, it doesn't kind of fit here.
I'm curious too about Attorney Gauze's position, right? Or what I think sort of is an absence of an important fact in the record at this point, which is how many exceptions to this 1-year policy did your client make historically? Let's say, over the past 2 years, how many exceptions for disability accommodation purposes did your client make?
If that's in the record.
Is that in the record?
It's not in the record. I know that, and what is in the record is that Portland Air Freight has not hired anyone who does not have a 1-year certification from Portland Air Freight's provider.
So the fact is not in the record, but I think I hear you asserting today that your client has made no accommodations or variations to that policy. Is that right?
Again,
I don't know.
that information isn't in the record, so we
Okay.
can't ask about it.
Okay, great. Can I ask though, don't you think that that is an important fact that should be in this record at this point?
Whether or not Portland Air Freight has over the years received a request for accommodation and has denied it? Is that what you're asking, Commissioner Sanders, or has allowed it?
Simply that, would you agree with me that those would be important facts to have in this record, for example?
I just wanna, and I'm sorry, this is your
Okay.
first meeting.
Of course.
But what the investigator does is a preliminary investigation, so they don't necessarily, I've heard a lot of conversation about what people may or may not learn in discovery and what may or may not be important based on the ultimate record in this case. But we are doing a preliminary sort of more, less in-depth, more early type of evaluation. I lost my words.
If you want me to address that without addressing that specific point, I can address, I think, the general issue that Commissioner Sanders is asking about there. Is that permissive?
I didn't ban anyone from doing anything. I just wanted to make sure we were all on the same page. I have tried, it always fails.
Context actually.
I guess I'll stay away from it completely because I don't want to get in trouble. I don't want to get Commissioner Sanders in trouble either.
Yeah.
Commissioner Sanders isn't in trouble.
But I am, right?
Context here
Always,
matters a
right.
lot, and understanding the role of the investigator here, certainly that's important. I'm simply suggesting that there are facts here that are not in the record that would certainly be helpful for commissioners to understand as we're thinking about this case.
And you will have an opportunity to ask the investigator questions as well.
Fantastic. So maybe I'll defer that, then Attorney Frame, to the investigator. Thank you.
That sounds fine to me.
Commissioner David.
Attorney Frame, I think I heard you just say a moment ago, maybe in response to Commissioner Douglas or Commissioner Sanders, that complainant could go to the provider even at the end of this, that he could have just gone to the provider and seen if he could get the 1-year certificate. Did you say that?
I said that at no point in time had complainant received a 1-year certificate from PAF's provider.
Right, but he couldn't go to the provider and ask for that appointment without being referred, right?
Correct.
Okay. And you said that the evidence about the phone call from Mr. Marion is that he testified that he made a phone call, and this is after complainant reaches out and says, I've seen the ad that you're hiring. Mr. Marion says he made a phone call to him. Complainant says he didn't get the phone call. Is that correct?
Correct.
Why did Mr. Marion call?
I think Mr. Marion was going to explain what would happen with the customer.
No, I thought this was it. I thought this was after the customer had come back and there was public indication that they were hiring.
Right, I believe the testimony from the complainant was that he had called and said, what's the deal? You told me last week you weren't hiring, and now I'm seeing on Indeed that you are. And
Right.
Mr. Marion would testify with the investigator.
Please, I missed this, but that person is not named in the report, so please don't.
I'm sorry.
The employee.
So I believe what happened, Commissioner, is that Mr. James, the complainant, called and asked about a position. The safety director said, "We no longer have a job for you." Mr. James then, a week later or so, a little over a week, called and said, "What's the deal?
Right.
You said you don't have a job for me, and I'm seeing on Indeed you're hiring." And the safety director, caught myself there, was intending to call back to explain what had happened with the customer. And they're I mean, those are verifiable facts, and the investigator can speak to that too. But the president of Portland Air Freight testified about that customer issue very clearly in the Issues and Resolutions Conference.
So you're not claiming that the safety director was calling him back to say, yes, we are hiring, the ads in the paper are correct, and we'll refer you to our provider and see if you get the certificate?
The safety director was intending to call back to explain why they were now hiring, because I think the complaint was, what's the deal? Now, had that conversation taken place, we're getting into supposition here, but presumably Mr. James may have said, well, what about me? And the safety director would have said, if you complete the requirements that we've had that have been clear in the job description and in the Indeed posting and everything else, you would be considered.
So it's a missing phone call, an uncertainty about whether a phone call was received or not. It's all a misunderstanding. If they'd made that connection and referred them to the provider, and if Mr. Goss's assertion is correct, that obviously he would have gotten the certificate, but at least he would have been referred. He would have been referred back to the provider, and we know whether he got the certificate or not, right? It's all a misunderstanding of the phone call.
I'm not sure I understand the question. I'm sorry.
Never mind. Thank you.
I'm happy to answer. I just didn't understand.
I understand you are. I'm getting argumentative, which is something I try not. Poor Barbara wraps my notes.
I'm gonna bring her a ruler next time.
Might be in trouble.
Any further questions for Attorney Frame? Seeing none, Attorney Frame, you'll have a minute when we come back to you. Attorney Goss, you have 1 minute. You have anything to add?
Thank you. If we rewind to William's November 5th email, that's where he tells the safety director that he had been cleared and asked Portland Air Freight if it was going to refer him back. So Portland Air Freight, as of that time, knew that William had done everything that he needed to do to be returned and get a 1-year plus certification. The second contact on November 21st was actually an email from William, not a phone call. And the email asked about the job postings, and he never heard back. I believe the safety director stated during the fact-finding conference that he intended to tell William or to arrange to have William go back and get certified by its provider. The safety director, again, at that point knew that William was eligible for a 1-year plus certification. I think that, one point I want to make in my last couple seconds is that because we've talked a lot here today about how this is a preliminary investigation, obviously there'll be further discovery later. I think it's important to keep in mind the reasonable ground standard in that context, which is at least an even chance of being.
That is your time, Attorney Goss.
Thank you.
I will let you finish your thought at least.
At least an even chance of being successful in a court action where there is full discovery.
Any more questions for Attorney Goss, Commissioner O'Brien?
Thank you. I think I'm seeing this through a different lens as I put my glasses on. The complainant, as I understand it, had driven before. He could drive. So are you saying that there was a reasonable accommodation requested? I'm reading, I think it's the investigative report, that generally the respondent is only required to provide a reasonable accommodation if complainant requests one. So where did he request one? It seems to me, and I'm sure you'll correct me, it seems to me that he had one leg shorter than the other, he had disability, what's the, it seems to me that he didn't complete the requirements. And really, what does it have to do with one leg being shorter than the other?
Their own medical provider sent them a copy of the letter that their medical provider sent for a neurology consult at the conclusion of the 6 months. That note said that he has CP, which is the reason that we are sending him for a consult. And again, I think it's very important to keep in mind that their medical provider is saying that he is safe to drive at that point. The medical provider has the option of saying, I'm going to defer until seen by a neurologist. I can't say one way or the other. The medical provider does not do that. Medical provider has the option of saying unsafe, does not do that. Medical provider says safe, which is all DOT requires. And then says within a 6-month period, because he has a history of CP. I've seen him, I've evaluated him. I don't see a problem. One leg is a little shorter than the other, but because he has this history, I would like sometime within the next 6 months that you confirm it. That in and of itself, to prevent him from being hired as of September 22nd, which is 6 weeks before they say they lost a customer, that's 6 weeks of employment that he was excluded from, violated the Maine Human Rights Act. And so that's number one. And then number two, in terms of the reasonable accommodation, everything that he's providing to them is essentially asking for a reasonable accommodation. He's providing them a certification from his own. He's providing a certification from theirs. He's providing a note from his doctor saying, is this enough? That's all that somebody needs to do to request a reasonable accommodation. People are not going through their lives thinking ADA, Maine Human Rights Act. Nobody has an obligation to say, I would like to have a reasonable accommodation for my disability. The courts are consistent in saying that.
Okay, thank you.
Any other questions for Attorney Gause? Great, thank you, Attorney.
I do, if I may. Yeah. Attorney Gause, is there a difference between the two findings here? One is second one is discrimination on failure to accommodate, make a reasonable accommodation. And that I'm impressed by, and I'm impressed by the argument that clearly he's making that request by the intercourse of back and forth and going to the neurologist and that kind of thing, which is different from failing to hire, which seems to be more asking us to say that they don't have a right to have that regulation in place at all, that it screens out disabled people. Aren't they different things, the two different issues that are presented in the findings?
They are different things. The reasonable accommodation violation requires no intent to discriminate. When I say to someone, I'm not going to hire you because of your disability, that is intentional discrimination. That's one of the two recommendations. We are saying that there was intentional discrimination here because if we look objectively at all of the evidence and their failure to hire him when they were urgently hiring and they knew that he had CP at that point, we say that the reason that they didn't hire him at that point, and it doesn't have to be glaring, obviously, it's just an inference based on all of these facts. We say that the reason must have been his CP because they don't offer another good one. But then the second recommendation is reasonable accommodation, failure to accommodate, failure to modify their 1-year certification requirement. There's no requirement of intentional discrimination with a failure to accommodate claim.
And then you would argue, would you not, that they could accommodate him by a temporary thing and refer him back and still hire him based on what he'd been through already and the 6-month certificate and his own provider and say, okay, we'll accommodate you by hiring you, but you gotta get yourself over to our provider.
Absolutely.
And that it's contingent.
Absolutely. He's already been trained. He's got certifications galore, including by
Right.
their provider. He's safe to drive. Just hire him.
Thank you.
Any other questions for Attorney Gause? Right, seeing none, thank you, Attorney Gause. Attorney Frame, you have 1 minute.
Thank you. I think it's important, Attorney Gause talked about, certifications galore, and he's okay to drive. And I think there was a question about Mr. James, he'd driven before and clearly could drive. Lost in this is that an employer is able to have its own qualifications for safety. Some employers may have less of an emphasis on safety or on retention than Portland Air Freight. Some certainly have more. But the fact that he had driven before and could drive doesn't mean that Portland Air Freight can accept that at face value and hire him. Again, Portland Air Freight wanted someone who had been vetted by their provider and had the certification that they determined was important for any number of factors, all of which, again, I think are clearly job related and consistent with business necessity in terms of the rationale for those workplace requirements. Thank you.
Thank you, just to clarify, because we really want to get to Angela. But when I asked that question, I'm trying to get this straight. When I asked the question, when I commented that he had driven and he could drive, to me says that, so how can you say that he discriminated? I'm on your side, I think. It's the policy itself, right? It's a policy itself that it's their standard policy. Right.
Right. And I think the investigator spoke to that piece, that the Mr. James's disability did not prevent him from going to the provider and ultimately achieving that.
Thank you.
Any other questions for Attorney Frame? Seeing none, thank you, Attorney Frame. We will now hear from Investigator Morse.
Hi there, my name is Angela Morse. I was the investigator assigned to today's case. I think the parties did a great job laying out their arguments, and some excellent questions were asked. So I'm not going to rehash any of that information. One thing I did want to clarify is that during the October 18th conference, the complainant did state that he missed a call from safety director, and he decided not to call back because his girlfriend advised him he should only respond in email. And I'm welcome any other questions.
Yes.
Yeah, all right. What you just said, right? So the complainant said he missed a call. This was this November 21st situation.
Mm-hmm.
At the end of, where he's now discovered that they're hiring, and he contacts them and says, what's the deal? And what I hear you saying is that the complainant has now receiving information that the complainant actually said he missed a call. Is that the call?
That was the call. That was the call that the safety director explained. So I think the safety director understood the looks of the situation. That, in a short time frame, the company had gone from, losing business and not hiring to launching a hiring campaign. That's why the safety director wanted to have that conversation over the phone, which to me would be understandable versus, via email.
Okay. And
I did, sorry.
You go ahead. I'm sorry.
Yeah. And I just wanted to make sure I was correct on that. So I did just review during our conversation here. I did review my notes from the conference, and I did very clearly write that the complainant's girlfriend had advised him not to respond and to make sure everything was in via email at that point.
Okay, but your information, at least so far, is that the complainant did not respond via email either. He didn't call back, he didn't take the call, he didn't call back, he didn't email.
I don't believe so. I'm not 100% sure about that. I am sure that the call was received. I do not believe that any voicemail message was left, which to me would also make sense. If you had kind of a complex situation, you'd probably speak to somebody versus leaving a message. I don't even know if there was a message left that said, give me a call back. Yes, it was my understanding at that point, complainant was going to seek legal counsel to protect his rights. So that kind of quashed any more conversations.
All right, and on that last point in your report, it says director called complainant to explain the situation and relayed he would be eligible for hire after he completed the outstanding pre-employment requirements. But there was no voicemail. This is just director testifying about what the reason for the call, correct?
Correct. That's what he said during our October 18th conference.
Thank you. It's very helpful.
Any other questions?
Yeah, just to follow up what Commissioner Douglas just said, that the intent of the call was to tell him that he would be eligible if he completed the requirements?
Yes, so the safety director stated that, I think the main point of the phone call, because the email that he had received from the complainant was kind of short. I believe it ended with some ellipses, basically saying like, okay, I see you guys are hiring, basically like what's going on. And the safety director had called to explain the situation. I think that was the main point of that call, is to explain what was going on, as far as, losing a customer that comprised 20% of their business and then launching the hiring campaign. But the safety director did say that he was going to discuss, the eligibility.
That he was
moving
going to
forward.
discuss the eligibility.
Mhm.
It seems to me critical.
Yeah, just to briefly follow up. I am correct, I believe, in understanding that at no time after this call was made, there was no email, right?
No, to my understanding, safety director did not email. He
So
made
there's
the
no-
call.
Right, there's no email, there's no voicemail. Complainant has no idea what director's intent was.
I'm not-
It's
yeah.
just this call as far as we know, correct?
I'm not sure about the voicemail component. My understanding that if there was a voicemail, it wasn't anything substantive, because the safety director wanted to have that conversation in real time with the complainant.
Something along the lines of give me a call back.
Yes, that might have happened. I to be honest, I don't know if that was discussed, whether a voicemail was left or not.
All right, thank you.
Mhm.
Any other questions for the investigator? All right, seeing none, thank you, Angela.
It's just.
We've heard from the parties and the investigator. At this point, we're looking for.
Can I ask counsel a question?
Sure.
Barbara, is it the case that there is a requirement to make a reasonable accommodation in the hiring process, as well as for an employee that comes along and is disabled and says, I need a accommodation?
Subject to all the usual reasonable accommodation stuff, yes.
Yes, okay.
So we've heard from the parties and the investigator. At this point, we'll be looking for a motion. There are two proposed findings.
Go into recess.
I know I could use a nap.
Commissioner O'Brien.
Gonna go out there and say, and take them together and say that there are no reasonable grounds to believe that Portland Air Freight discriminated against William James on the basis of disability by failing to hire and discharge him. And no reasonable grounds to believe that Portland Air Freight discriminated on the basis of disability by denying him a reasonable accommodation. And the complaint should be dismissed.
It's been moved. Do we have a second?
That's what I thought.
All right, no second, the motion fails. Do I have another motion?
I'd like, yes.
Okay.
I'd like to take them separately.
Okay,
My intention is on the second one to say that there's a failure to engage in the process and make a reasonable accommodation. So the motion is going to be on the first one. Maybe I'm wrong, but it seems to me that the first one is more directed to saying that we're finding that they don't have a right to make the policy. And that bothers me. I think they do. So my motion is to find that there are no reasonable grounds to believe that Portland Air Freight discriminated against complainant on the basis of disability by failing to hire him. And then we'll deal with one at a time.
Okay, I'll run back. I'll second.
okay, so just, that was no reasonable grounds on the first recommended.
Correct.
Okay, and I have a second from Commissioner O'Brien. Okay, it's been moved and seconded. Any discussion?
Any comment?
No.
No. Thank you for your help.
Sorry, this part is up to you, not up to me.
No, I tend to agree, yeah.
Yeah, I don't know. This is
It's tough.
this is a tough case. And I think that first question is
Yeah.
really close. It's a close call. I mean, just going through the analysis in the report and under the MHRA, you know, he didn't establish the minimum requirements for the job. I think he did. I understand the policy requirement. I think he did, and I think he would have. The non-discriminatory reason, the no business, I don't know that we have enough information to conclude whether or not, you know, who's going to prevail at trial, given an even chance, and you know, and the lack of the 1-year certification, I think he would have obtained that. You know, and if it's this business about the call that was received, the information at the end from the investigator is very, very helpful, but I don't know, I'm not about to say, this vote's gonna be like how I order dinner. Waiter comes over, I make a decision, but this is really tough. I'm not convinced that you're right, and I'm not convinced that you're wrong.
So on that note as well, I have similar concerns that, you know, the record that we have is not developed enough at this point for us to be able to make a finding. And if that's the case, my sense, although, you know, invite my colleagues to correct me if I'm wrong, and certainly counsel as well, if there's not enough development in the record, we have to make a finding of no reasonable grounds.
The standard is tie goes to the runner. So the complaint, if it's genuinely 50-50.
Yeah, in terms of our discussion about the motion, I told you that I intend to move on the second one, that there are reasonable grounds to believe that there's discrimination. I'm just concerned about the first one, failure to hire is a far-reaching statement about what seems to me, or at least I don't have enough information to say, no, that's a discriminatory policy, and I'm going to set the standard for the industry that says you can't require 1 year in the face of testimony that that's policy they've had for many years, that it is an industry standard, doesn't seem to me unreasonable. But they didn't follow through at the end with this history of getting the phone call made, making the second phone call, whatever it is, that tie goes to the runner. The runner's being a little cautious too when his girlfriend says, no, you better get it in writing, this could be a legal situation. So I'm just concerned about the first one as a statement that the policy screens out disabled people. And I don't think that's the intent of the policy, nor do I have enough information to go that far into that business world. And that's my thinking in trying to separate. So
I will just remind you all, just because guessing. If there is a tie vote, since there are only 4 of you today,
Right.
the default is to the investigator's findings. So if this is a 2-2 vote, the result will be no reasonable grounds on the first finding.
So you can make your statement with the vote and you'll lose.
You make, is there a motion on the table?
Yes.
There is.
And you seconded it.
I was gonna say,
Yeah.
is that what I said?
So,
I'm like the Katanji Brown Jackson of this commission. One side of more 4 to 1 votes, and that's fine. I'm good with it.
Lisa.
all right. So we have any more discussion?
Because we'll be talking about it all.
Okay, great. All right, Commissioner David. So the motion is no reasonable grounds on the first recommended finding. Commissioner David,
Yes.
Commissioner O'Brien,
Yes.
Commissioner Douglas,
No,
Commissioner Sanders.
Yes.
Okay. So.
See how it feels.
All right, Commissioner David.
I would move that we find that there are reasonable grounds to believe that Portland Air Freight discriminated against complainant on the basis of disability by denying a reasonable accommodation.
second.
And speaking to that, clearly this is the tie, clearly, that's argument. The tie goes to the runner about the intent at that point. They certainly knew that what was going on with him, and they didn't follow up in terms of getting a hold of him. I tend to believe, one, that the temporary hold on hiring and then publicizing it is all in good faith. I don't believe that's part of a plot to discriminate against this one guy. But he's asking for an accommodation. He's participating with them initially. Oh, I've done your neurologist. What else do you want from me? Now you are hiring. He gets a phone call. Stupid that the girlfriend gave him the wrong advice, but that's my thing.
Further discussion.
No.
I didn't.
It's
Been moved and seconded. No further discussion. Commissioner David.
And we're voting that there are reasonable.
We are voting that there are reasonable grounds to believe that respondent discriminated against complainant on the basis of disability by denying him a reasonable accommodation.
Yes.
Commissioner O'Brien,
No.
Commissioner Douglas.
yes.
Commissioner Sanders.
Yes.
Okay. So no reasonable grounds on the first recommended finding, reasonable grounds on the second recommended finding. We thank the parties for their participation and we will send a letter confirming the results of the hearing.
And you ready to go on? Second case is Gallant versus Greater Brunswick Housing et al. Bedford Housing, Jameson and Bard. The recommendation is for a finding of reasonable grounds. And therefore we will hear from the respondent.
Okay, Attorney Lee.
Good morning. I was able during that last hearing to drive from my home to the place where Kit will be very shortly, so I can establish the form.
I apologize for pulling you away from your work session. Here
No
we are.
problem, no problem.
I'm looking on Zoom, nothing has happened yet. So you have 10 minutes. Would you like to reserve any of your time?
Sure, I'll reserve a minute, though I doubt I will use anywhere close to the 10 minutes.
Okay, whenever you're ready.
So I represent Greater Brunswick Housing Corporation, and you'll see that our position from our submission is a purely legal one. The GBHC is solely the owner and is not involved in the management of the building. And so given the structure of the housing portion of the MHRC, the liable parties here, if there is any truth to the allegations regarding discrimination, are not GBHC itself, nor any employees of GBHC for which GBHC could be held vicariously liable. So with that, I'm happy to answer any questions. And I reserve that 1 minute.
Oh, you can reserve the whole 9 minutes.
Sure.
Great. Okay. Any questions for Attorney Lee?
Yeah.
Commissioner David.
Attorney Lee, how can the owner be not responsible for who it hires to carry out discriminatory policies?
It could be held responsible for whom it hires. It did not hire any of the individuals involved here.
Well, how did Tedford get to be running the project?
The building is leased to Tedford to manage. And so none of the employees are ones that were hired by GBHC. They were hired by Tedford.
Any further questions for
Not
Attorney Lee?
Not of Attorney Lee, but of counsel. Give us guidance.
The Human Rights Commission says that it is unlawful housing discrimination for any owner to do many, many things.
Right.
So as the owner of the building under the Maine Human Rights Act.
So that's creating an obligation in the litany of the people that are covered that are recited in the act as to who has to comply.
Correct.
Thank you.
Any further questions for Attorney Lee? Seeing none, like I said, you'll have about 9 minutes left when you come back to you.
Thank you.
Attorney Frame, welcome back.
Happy to be here again.
Would you like to reserve any of your time?
Sure, I'll reserve a minute.
Okay, whenever you're ready, go ahead.
Good morning, everyone. Again, Greg Frame, and I represent both Tedford Housing and two employees who were named Giff Jameson and Kami Bard. As you know from reading the materials, Tedford Housing is a short-term emergency housing shelter. As part of the work that the guests have when they come to Tedford Housing, they are assigned a case manager. In this particular instance, the complainant's case manager was a woman named Kami Bard. I guess at the outset, it's important to understand, I think you've perhaps seen this, that Tedford Housing has an assistance animal policy. It's actually fairly detailed, and it involves reference to the Maine Human Rights Commission and communications actually with the Human Rights Commission when they were developing it years ago. But getting back to Kami Bard, who I think is kind of critical importance here, you know, the role of the case manager is to provide guidance and direction and case management on any number of issues. So in this particular case, Ms. Bard dealt with the complainant, assisted the complainant with schooling issues for her children, helping to encouraging vaccinations for kids, work issues, obviously housing search to get more permanent housing. Tedford's is not a long-term solution, as well as providing healthcare resources. The policy on assistance animals is that the guest, that's what they call the folks who live at Tedford's, must have medical certification of the need and must have the vaccinations. So that's and there's no disagreement. There's been no disagreement in the record that upon entering the shelter, the complainant didn't provide either of these and was instructed that they were needed. For a period of many months, almost not quite a year, there were a number of planned meetings between Kami Bard and the complainant. And those are reflected in the voluminous case management notes. And in fact, the dogs were very rarely, if at all, mentioned. When complainant finally provided in August of 2023 the documentation that she knew was required, the dogs were permitted. So I think it's important to understand kind of the timeline here. Complainant did in fact have a doctor's note for the certification of the assistance animals on May 25th, but didn't submit that till August 23rd, and then didn't submit the vaccination records till 2 days later. And that was immediately, the dogs were immediately provided. I want to address a couple specific disagreements with the investigator's finding. I think the investigator, one of the things she mentioned was that an accommodation, I'm paraphrasing, but an accommodation delayed is an accommodation denied. There was discussion in December 2022 around the dog, and it was clear that there was a requirement of the certification. In fact, complainant in the hours and hours of audio tape that were submitted, if you would listen to it, would hear her acknowledging that she was alerted to that in December of 2022. There's a discussion again in May of 2023, and she submitted the documentation in August of 2023. So the cause of the delay, I would submit, is not on Tedford's. Another piece that I think is important here is the investigator, again paraphrasing, said that dissuasion is effectively a denial. And I think that really gets to the heart of what case managers do. Case managers are doing great work, and oftentimes it's thankless work. A lot of times they're trying to assist folks who are resistant to that assistance, or for any number of reasons. And we see that here in the voluminous documentation here. Miss Bard was trying to provide complainant with guidance, sometimes persuading her, you need to get you need to do certain things with the kids in terms of schooling or vaccination, and sometimes dissuading, and candidly, she did dissuade that, 2 dogs in a 2-bedroom apartment with an adult and 6 children was not wise. That's part of her job. That's what case managers are doing. But to be clear, she and Tedford's never denied that the animals, and in fact, when they were provided, when the documentation was provided, they moved forward as required. The final piece is the audio. There's an excerpted piece of there were hours of audio tape submitted by complainant, and excerpted from that audio is a small piece. I listened to all the audio. I can tell you throughout, Miss Bard is professional. Miss Bard is patient. Miss Bard is doing her job. In the excerpted piece, Miss Bard was approached by complainant while Miss Bard is actually navigating another family's crisis. In that excerpted piece, the complainant acknowledges that she was asked about the documentation needed to support the assistance animals in December 2022, and had not provided it. Complainant noted that she had it and still didn't submit it again for another 3 months. Bard, in that excerpted piece, noted that if complainant wanted the dogs in December of 2022, she needed to provide the documentation at that time. That's consistent with our policy, and she acknowledged that. So, in short here, I understand the investigator's attempt here to thread a needle, but this case to me comes down to a case manager doing what case managers do. A complainant who acknowledged the policy and that she knew of the documentation needed and did not provide it, and the shelter readily approving the assistance animals when that documentation, the 2 pieces of documentation, were provided. So I don't know where I am in my time, but I appreciate the effort the opportunity to speak with you today. Thanks.
Thank you. You'll have about 2.5 minutes when we come back to you. Any questions for, yes, Commissioner David?
Attorney Frame, the excerpted conversation that's in the investigator's report says that complainant says, I was told in the beginning that I could have my dogs and that, I'm sorry, what's her name? Ms. Bard, said, right, not two big dogs, no. Is it do you agree that that's accurately transcribed? Since you listened to the tape and I haven't,
I agree that's accurately transcribed.
isn't that incorrect? Telling her that she can't have her dogs?
Well, and I agreed, and I think at the end, if you look, and I'm sure you have, Commissioner, she further says, that's just not going to work given. I think she talks about the size of the.
I understand
number
that she's
of
doing her
animals.
social function and she's trying to talk her out of it, and I don't fault her for that, and I'm sure she's well-meaning and that it's crazy to have those dogs in that apartment. That's not the law. Correct?
Yeah, the size of the dogs. You're absolutely right. The size of the dogs does not matter, except as it relates to health and safety. If there's a health and safety issue.
Okay. And you were saying that complainant understood from Ms. Bard that she could have the dogs if she got the documentation, and that this all turns on not getting the piece of paper to them until August.
Yeah, she says, if you look down further, Commissioner, she says there's a paper that you have them registered as an emotional support. I'm pretty sure I asked you about that. And she said, yes, you had asked me about that. So she acknowledged that she needed to provide that. And then she says, but I always thought all you had to do was get something from your doctor. And so the complainant acknowledges that she was notified in December of that need.
She says, are they papered? Like, do you have the paperwork for emotional support? I have it from my doctor. What do you mean papers otherwise? It's not like legal papers. You asked me about that, but I always thought all you had to do was get something from your doctor. Yeah, she said, we've already had to had it and been able to submit it to me at that point.
Right. I think in the context of this, Commissioner, this was in a discussion outside of the picnic table where Miss Bard, and I think she would say, and I think she did say with the investigator, she was definitely distracted because she was dealing with another issue. But she said, if you had wanted the dogs in December, you needed to have provided me with the certification in December. And the complainant acknowledged that she had been asked for that in December.
Is it your position that she doesn't get the paperwork until May? That's what I understood.
She doesn't get. Sorry.
She doesn't get the paperwork until May, or don't we know? What is your position?
I lost my earphones. Can you guys hear me? I apologize.
Yep.
Yes. Yeah.
Okay.
Can you hear us?
Yep. So timing wise, complainant got the note from her doctor finally in May.
Right.
Didn't get certification and ultimately submitted that, Commissioner, in August. At the time she submitted it in August, she still didn't have the up-to-date vaccinations, which I don't need to explain why that's important from a safety standpoint. 2 days later, she provided that, and at that point, she was provided with the assistance animals.
When did she see the other tenant have an assistance animal?
I think she saw, if I'm correct. It's sometime between December and May, she sees a cat,
Right.
Commissioner, and asks about that.
She's not paying $1,000 a month if she understands all she has to do is get a note, correct? I mean, her position is that she knows that they're assistance animals. But her position is that she's been told that she can't have them, which seems to be confirmed by this expert. No, you can't have two big dogs. And she's paying $1,000 a month on that until she sees somebody else has one and goes after the documentation. Isn't that plaintiff's theory of the case?
You'll have to ask plaintiff. I mean, I think complainant
I'm asking you to
knew,
respond to that theory.
yeah, complainant knew that there were assistance animals on site. She saw one, and in fact, Tedford's has had numerous assistance animals over the years.
Right, and they have the policy and they know what it is, but the tenant didn't know it.
Well, the tenant did know. The tenant did know, and Kami Bard testified. The tenant did know in December when she moved in that she needed to have certification and vaccination.
Thank you.
Commissioner Douglas.
Attorney Frame, good morning again. So just to follow up on Commissioner David's questions, at the end of this excerpt, I mean, so the way I read this recording, right, this May 25 conversation is, you know, the complainant asks about the service animals. First, she's flatly told, you know, it's just not going to work. Right. And as Commissioner David said, I understand she's doing her social work function. I get that. But then at the end here, she starts asking about papers. And then she says, yeah, you would already had to submit those, you know, in order to get your dogs in at this point. Right. Because it seems clear that complainants say, oh, if I need paperwork, I'm going to get paperwork. I mean, and so on this last point, isn't that untrue? I mean, because later on she comes up with the paperwork and she's allowed to have the dogs.
Well, I think, Commissioner, at the end, she says, yeah, you would have already had to have had it and been able to submit it to me at that point. She's referring to December. There was further communication in that audio about why wasn't I allowed to have the animals in December. And Kami Bard said at that point, at any point in time, and she's referring to that point, you would need to provide the documentation needed.
Right. I just want to make sure I'm not missing something here, right? So what I'm saying is, I mean, the way I read this, right, is that Ms. Bard has decided that having these dogs here is just something that needs to not happen. So first she says the dogs are too big, and then she says you're late submitting your paperwork, so it can't happen now. You have a different interpretation on that second point.
Yeah, I don't read that, sir, to say that you're late submitting your paperwork and you're out of luck, because in fact, when she submitted the paperwork, she got it. I think I read that if you had wanted the dogs in December, you would needed to have submitted it to me at that point. So I think that's where I differ with your interpretation, or at least your questioning.
Okay. All right. Thank you.
Commissioner Sanders.
Hi again. Attorney Frame, I have a question about the letter you submitted in response to the investigator's report. And in particular, I'll direct your attention to page 3, first full paragraph from the bottom that starts with the investigator's finding that dissuading an individual, ... Are you there?
Yep.
Okay, great. So that your sentence reads, the investigators finding that, quote, dissuading an individual from having their assistance animal is effectively a denial, has no basis, end quote. I want to drill in on that representation and try to better understand, when you say there's no basis, do you mean no basis in law, or do you mean no basis in fact, or do you mean something different?
So in that particular, the Tedford's did not deny complainant the assistance animal. Tedford's Kami Bard, and I think the earlier commissioner's question got to this, and I think it's candidly a challenging part of the case for me, right? Is that Kami Bard's role is to we ask our case managers, whether it's at Tedford's or anywhere, to have difficult conversations with people and to provide guidance and insight, because the case managers are not in crisis and they're dealing with people who are necessarily in crisis. So I don't believe that the dissuasion here is a denial. Dissuading someone from doing something is not a denial. It's a matter of fact. I don't believe, and I don't believe it's a denial as a matter of law. And I think the proof is in the fact that when the documentation was provided, the animals were immediately permitted.
Thank you. That commentary is certainly troubling to me. I see the, plain text of the transcribed conversation in the investigator's report, clearly as interference with complainant's right to public accommodation, right, to have an assistance animal. And to the extent that, case manager Ms. Bard is doing her job appropriately, aren't you sort of ignoring an important caveat here, right? Which is the case manager's job is not, and I'll go there next, but the case manager's job certainly is to help provide information, connection to resources in the community, and the like, right? Understanding that it's important to make sure that the client understands what their rights are under Maine law. Isn't that the case?
Well, I guess I would argue that the case manager did inform Ms. Bard of her rights under the law. Ms. Bard was aware, acknowledged that she was aware in December of 2022. I think that's December 2022, that she could have the animals provided that there were the appropriate documentation. So I think she did do that. I mean, is this dissuasion challenging? Yes, for sure. I understand where you're struggling, Commissioner Sanders.
Thank you. And then just last question, and this may not drive the legal analysis, but it really caught my attention. And so I just wanted to press you on this a little bit, which is the next sentence in that paragraph reads, the role of the case manager is at times exactly this, to dissuade somebody from making poor choices. And my worry is that you've misstated the role of a case manager here. So help me understand, Tedford's sort of philosophy on how it provides case management services.
Candidly, I dealt with Tedford's in case management on this particular issue. I know their philosophy on case management through just discussion with them and a review of the job description. I think I put Commissioner Sanders in our initial submission. I put it included a copy of the job description, and I included a summary of in our initial submission of the commission, just kind of generally what the case manager does. Case managers are assisting folks in crisis and trying to provide them with resources, sometimes with resources, sometimes with direction, sometimes with guidance, sometimes with advice. there's, I think, 37 pages of case management notes in which Ms. Bard is doing any number of things here. And it's also important, I think, to recognize, I think you do, that the excerpt that is troubling is one excerpt out of like 4 hours or however longer of communication where there's lots of back and forth, and Ms. Bard is working with complainant on any number of issues. Again, from vaccination to schooling to job search to work search. So that's probably a long answer to a short question. The case manager is there to assist and guide in all range of things, and the case management services depend oftentimes on what's the age of the individual, right? Is the individual older so they're able to access certain resources versus younger with kids, and are they able to access different resources? So the case managers are navigating a number of different issues with the guests in this particular instance.
Any other questions for Attorney Frame?
Just one question, because you keep mentioning that there are additional recordings that, you know, we're not seeing in this report. Is there anything in the recordings from this particular day, I think it's May 25, that's in the record in this case, that's not in the report, that you feel would be helpful for us to know?
No, I think that, you know, the recordings didn't come from us. You know, I'm fully aware that Maine is a one-party consent state, and so there's no requirement. I don't know. We didn't have custody, Commissioner, or control over the recording, so I don't know what wasn't provided and what was. I would submit to you that the recordings evidence Kami Bard doing her job and doing it really well, patient, professional, guiding at times, advising at times. That's the role.
Thank you.
Any further questions for Attorney Frame? Being none at this time, we'll hear from complainant. Ms. Galland, I see that you're with us on Zoom. Can you unmute yourself and turn on your video if you have it?
All right, I don't know how to turn my video on.
Okay, that's fine. You have 10 minutes. Do you want to save any of that time?
Yeah, I'll save 2 minutes.
Okay, whenever you're ready, go ahead.
All right, so my family had been homeless for about a year when we got into, I got a call. I was staying in Pittsfield at a motel, got a call from Kami Bard saying that our name had come up on the list. One of the first things I asked was about my emotional support animals. She said, no animals at all. Never once during that phone conversation did she tell me, you just have to get paperwork and, you know, whatever, vaccinations, proof. So I moved there and I just thought maybe it was different, honestly, because it's a shelter, even though it's your own apartment there. And I never really thought anything about it until in May, I see a cat in somebody's window. That's when I had a meeting with Kami. I had already been struggling mentally. I had already been seeing my doctor. My dogs are boarded 2 hours away, and I very rarely ever got to see them. I wasn't speaking to her. Well, it was a Thursday, and I said, hey, can I have a meeting with you on Monday? Because I know she doesn't work Fridays. She said, oh, I can talk right now. So I was outside with my kids playing. I sat at the picnic table waiting for her. She came back out and talked to me. Yes, there was some family, other children being loud, doing whatever, but she wasn't actively dealing with a crisis at the moment. I sat there and I waited for her to come out. During that conversation, I was pretty upset. I said, so-and-so has a cat. I was told I couldn't have my animals here. Right. Not 2 large dogs, she said. I said, I don't know why size would matter, but, and the conversation went on. At no point did I ever acknowledge that I had heard her say anything about just getting the paperwork that I needed in December, or I would have had my dogs with me. My dogs are 4 years old. They've always been with me. And she said, it won't work. I said, it won't work. And she said, no, it won't work. And she did say the 2 bedrooms, 6 kids, all that. So at that point, she asked me if I had paperwork. I told her I had it from my doctor. And then she said, you would have had to have that basically prior to moving here. She never said in December or anything. That was not even the truth. I mean, if you could go back and listen to the audio, you'd hear that that's not what was said in that moment. So she flat out told me, no, it won't work. So I kind of gave up. I mean, there was some other issues with other tenants, and I was honestly nervous about any reasons for them to kick me out, and I had nowhere to go with my kids. So it wasn't until August that I had secured housing. I knew I was going. So I sent Kami a text. I said, basically, I wanted to know why I was denied to have my emotional support animals. And then she comes back saying I was never denied and all this stuff. And then she has a meeting with, I said I wanted to have a meeting with her and Gifford Jameson, the director. Well, they omitted me from the meeting, but all of a sudden the next day I got a text from her saying I could have my animals once I provided that. Had I known all this in the beginning, obviously I would have done anything I could do. And as far as what she does as a case manager, really wasn't what a case manager should be doing. We didn't have those meetings. We had a few meetings, but not regularly. Anytime I did ask for any kind of assistance, I was looked at like I shouldn't need it. They never helped me try to find work. Even visit them.
Ms. Gallant, your audio is cutting in and out.
Oh.
So the last thing we heard was that you couldn't visit them.
Right. So I couldn't even visit them. It was just really a difficult time in my life, on top of being homeless with my 6 kids and working full time, and then having to be away from them, and then having to pay the amount that I had to pay. All because somebody wanted to say no for whatever reasons. I don't know. It was just a very difficult time. And I find that many of the things that they said during even the investigator report, And in the lawyer's writings, that's not even a lot of facts in it. Mr. Frame said that in that audio recording, if you listen to it, it says, December. No, it doesn't. It clearly does not say that. And she told me a flat out no. And I did speak to Gifford Jameson, the director, the following day. And he said that he would talk to Kami and basically review what the guidelines are for emotional support animals. So, and he admits that in the investigator's report. So why would he have said that if I hadn't spoke to him about it? I guess I'm done for now. Let's save my time.
You'll have about 2.5 minutes left when we come back to you. Any questions for Ms. Gallant? Commissioner David.
Ms. Gallant, because you're not represented by counsel, I want to be careful here. I don't want you to be telling us stuff that's not in the record, but in the record, in your submissions to the investigator and at the conference, did you indicate what date you got the documentation that they were assistance animals?
I did. I received that May 25th. It was after I had seen the cat there.
Right. Okay. I got it. Thank you.
Any other questions for Ms. Gallant? Okay. Seeing none, Attorney Lee will return to you. You have 9 minutes and 10 seconds left. If there's anything you'd like to add, you should not feel obligated to use all of that time.
I definitely will go for any questions you have. To Commission Counsel Hirsch's statement regarding owner being an included part of the statute, I do not dispute that at all. It's amongst a list of different types of individuals or companies that can be held responsible. The existence of the owner is not in and of itself sufficient, though, for a finding of discrimination. You need to find that the owner itself discriminated. And I think that's why I mentioned the structure of the housing portion of the act as distinct from the employment portion of the act, in which individuals cannot be held liable. In the housing portion, individuals and lessees and owners, etc., can be held liable unto themselves for their own discrimination. And so the second portion of that is you could hold an employer, for instance, liable for the actions of the employee. That is correct under this construction of the act. We're not the employer, though, of any of the employees who are alleged to have committed discrimination here. And so there's basically 2 steps removed, and that's insufficient under just case law regarding vicarious liability, because we don't have any control over the individuals who are alleged to have done the discrimination here. And so again, you could hold an owner liable, but the circumstances here are not such that there's discrimination that can be found against the owner, GBHC.
Any questions for Attorney Lee?
Guess I was wondering if Commission Counsel had any response to what Attorney Lee had to say.
I'll say that is not how the commission has interpreted the Human Rights Act, and leave it at that.
And I'll say briefly, it's an interesting question, and one that I was not able to find any instructive case law regarding. And so our interpretation is that the legislature would not have altered the way that it constructed the housing portion of the act if it didn't intend to have sort of a cutout as to who's liable specifically for the discrimination.
Sanders.
Great. So I'll ask the question, and then, certainly you can advise on whether we defer it. But I can't help but wondering, I mean, Attorney Lee, don't your remedies sound in contract, right? So the contract that your client has with the management company who runs the facility, whatever that contract says, you know, will apportion liabilities and indemnification, right? Isn't that the remedy rather than asking from the standard?
I'm gonna be very careful because the contract is not part of the record,
Okay,
so.
good.
Yep.
Any other questions for Attorney Lee? All right, seeing none. Attorney Frame, you have 2.5 minutes.
Yeah, just very briefly, I think first, with regard to Ms. Gallant's comments around the role of the case manager, the record is replete with, I think, 37 pages of case management notes, meetings, phone calls. So the idea that Ms. Bard didn't take an interest in Ms. Gallant and wasn't working to in Ms. Gallant's best interest in any number of fashions, it's fiction. It's belied by the facts. The other piece I wanted to talk just briefly about is that Ms. Gallant alleges that Kami Bard said there are no dogs allowed on site, and maybe we're parsing out something, because in the context of coming on board, it is entirely possible that Kami Bard may have said this is a no pet facility, but she also, if and it sounds like it happened, if Miss Gallant said I have dogs, Kami Bard said, and it's in the audio, the only audio we have, Miss Gallant acknowledges that Miss Bard did ask her about the certification. That is the only audio we have, but it's an acknowledgement that I think we can infer from that Miss Bard was very clear that you can have dogs, but you need to have the certification needed to allow them to be here. And the two pieces were the medical documentation, which she ultimately received in May of 2023, and then the vaccinations, which she ultimately received in August of 2023. Thank you.
Questions for Attorney Frame? Commissioner David.
Attorney Frame, doesn't that make the argument for petitioner stronger, that she's told at intake that this is a no pet facility, that you can't have the dogs, and then she goes in and she pays $1,000 a month when she understands that she's being told she can't have the dogs, that she's never told that there's an exception for service animals, and she's got to figure that out herself when she sees the other tenant with the cat. Isn't it clear that on May 25th, that there's discrimination by the social worker, then saying at that point you would have had to do it at the intake, and that's why you're still denied by me. I'm telling you, you can't have those two big dogs.
First of all, Ms. Bard didn't deny saying on intake that you can't have dogs. So I think that's in the record, and the investigator can speak to that. She did say at that time, and Ms. Gallant acknowledged it, that in order to have dogs on site, you need to have paperwork. I mean, you look at the last line of the transcribed piece from complainant, you had asked me about that. So she acknowledged that at that time she had asked about that. When they're talking about having the dogs in December, Miss Bard is again being very, very clear. If you'd wanted the dogs then, you would have needed to have provided me the information that I told you about and that you acknowledged that I'd asked you about. So I don't agree that statement is against our interest.
Any other questions for Attorney Frame? Okay, seeing none. Ms. Gallant, I'm going to ask you to unmute yourself again, and you have about 2.5 minutes if there's anything else you'd like to add.
Okay, so regarding the paperwork for my emotional support animals. The only thing that I ever remember her saying about that was when I was trying to get into a house and she was talking to the landlord for me, and I asked her about my animals, and she said, well, do you have paperwork? That was discussion on paperwork, never ever at intake. And then I spoke to her in May, told her I had it, and I was still denied.
Any questions for Ms. Gallant? Right, seeing none, thank you very much. I am just gonna mute you again, but you can feel free to stay on video if you'd like, or you can turn it off. We've heard from the parties and their counsel. We will now hear from Investigator Brinkley.
Good morning, everyone. My name is Alex Brinley. I was the investigator for this case. So first off, I want to thank everyone here. I think my report and specifically the excerpt of the complainant's recording specifically speaks for itself. But to talk about a few points, most recently, Ms. Gallant mentioned a conversation about getting into a house. That's not in the record. However, I don't think it changes anything in this matter. There was the conversation between the alleged conversation in December wherein Ms. Bard may or may not have said no animals are allowed. That, if you look at page 4, is the very first paragraph of my analysis. On paragraph 3, regardless of whether or not Ms. Bard did say that there were no animals, it didn't really affect that my consideration in this case, because at that point, Ms. Gallant did not have the paperwork for her assistance animals. What I focused most on was the conversation that occurred on May 25th, which is reproduced previously in my report on page 2 and 3, wherein you can see Ms. Gallant talk about the size of the quote unquote therapy animal, and then saying that there's no way we can have 2 dogs and 6 kids in that apartment. It wouldn't work. It's a 2-bedroom. And then later on, asking if they have the paperwork for it and stating, as was previously mentioned, that the complainant would have already had to have had it and been able to submit it to me at that point. Essentially here, the determination in my case was that it is not a housing provider's it's not for the housing provider to determine whether or not a tenant can have an assistance animal. Complainant was prescribed it, and their job was to accept the paperwork and move forward, which they eventually did in August. However, based on the excerpt that I provided, it seemed to me in the record, and Ms. Gallant was pretty consistent in her testimony throughout the investigation, that she was in fact denied, if only dissuaded from having her assistance animals in May. And I'm open to any questions. Yes. I couldn't tell if anyone was talking. I have lost all audio. I'm so sorry, everyone. Okay. I mean, my audio is working fine. I just can't hear the commission.
We can hear you now.
Okay, perfect. I can hear you.
We couldn't hear you.
You couldn't hear me?
But just you had paused and then the audio cut out, so I don't think we missed anything. Was there anything you wanted to add?
No, I was saying I'm open to questions.
Great. Whoops. Any commissioner questions for Investigator Brindley? Yeah, Commissioner David.
Alex, thank you for this report. I understand the argument that trying to dissuade her is a discrimination on May 25th. Why, in your view, was there a delay from May 25th to August 25th, and she's still paying $1,000 a month?
I mean,
why does she submitted that?
My apologies. You heard from Ms. Gallant just now, and she reiterated the same thing during the issues and resolutions conference that I held. Essentially, after that May 25th conversation that Ms. Gallant had with Ms. Bard, she gave up until she knew that she had housing available.
Is there a date on the medical certificate from the provider?
May 25th.
Thank you.
Any further questions for Investigator Brindley? Seeing none, thank you, Alex.
Thank you.
We've heard from the parties and the investigator. At this point, we'd be looking for a motion. There is one proposed finding.
So I'll move that there are reasonable grounds to believe that Greater Brunswick Housing Corporation, Telford Housing, Gift Jameson and Cami Bard discriminated against the complainant on the basis of disability and conciliation to be attempted, basically to adopt the investigator's findings. I'm a little troubled by what I'm hearing about the owner who apparently hasn't done anything being held accountable on the MHRA. However, I'm going to defer to highly esteemed commission counsel on that point now. And otherwise, I think the May 25 reporting, it seems pretty clear that the case manager was trying to shut it down. So,
Do we have a second?
Yes, second.
sorry, I know I jumped. Sorry,
Moved and seconded. Any discussion?
too much coffee.
No, I mean, I completely agree with Commissioner Douglas. I also would observe that she doesn't pay $1,000 a month from December to May if she understands that all she has to do is go. I mean, she's had these animals for 4 years. She knows their disability and she knows that they're service animals. So it's pretty clear that they tried to shut her down then, and that they continued to try to shut her down in May. It's a little bit unclear why she finally does get the impetus. I mean, something else happens other than seeing the cat and getting the certification to take her to August and saying, doggone it, here it is, kind of thing. So I think there is discrimination. I also am bothered by the argument about the corporate entity. It seems as though that I don't know if there's a procedure in the commission's intake in terms of whether you make a considered judgment on what would have been a motion to dismiss, sort of kind of thing, that we don't belong in this case. But the council says that that's our interpretation of the act, and so I'll leave it to some judge down the road to tell us we're wrong.
For what it's worth, it's also HUD's interpretation of
Yeah,
the Fair
well,
Housing Act. It's not just me.
Highly esteemed counsel too, right?
Although I would obviously be enough.
You're enough for me.
Aw, thanks.
I also wanted to add, for what it's worth, that I think Attorney Frame has done a nice job arguing some pretty difficult cases this morning. Just
Yeah,
putting that out there.
and I want to say that I don't criticize Ms. Bard at all. I think she's doing what she ought to do as a social worker. There is a little friction about our service animal statute and how it applies in all these situations, and this is where we get to the sort of the fringes. It's a shelter, they're big dogs, blah blah blah, but that's what the statute says, and we're not going to change it now.
Any further discussion? All right, it's been moved and seconded to find reasonable grounds. If you vote yes, you are in agreement. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
All right, so the findings are reasonable grounds. We thank the parties and their counsel for participation, and the commission will send everybody a letter confirming the results of the hearing. That is the hearing agenda.
I've got the motion. You want to take a quick break?
Let's take a quick break
Yeah.
for tech and other needs.
Yeah.
Yeah, I won't tell.
It's helpful, Julie, thank you.
You're welcome.
Told me that I do have. Are you ready?
Ready, yep.
Yes, pursuant to one MRSA 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second.
Seconded, any discussion? If you vote yes, you are in agreement with the motion. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Yes.
All right. All right, so
Fugue state, apologies.
we will go into executive session, so we will turn off the camera and the microphone. Nope, just the camera.
Well,
The recording stays up on, yeah, that's stay on, we stay.
Oh, yeah.
we'll see you all next month. Thank you very much and welcome, Meg.
Thank you.